Let us start this discussion from introduction. Refugees have existed as long as history. The idea that a person who sought sanctuaries in a holy place could not be harmed without inviting divine retribution, the right to seek asylum and political exile were familiar to the ancient Greeks, ancient Egyptians, and ancient India. The first international coordination of refugee affairs came with the creation of High Commissioner for Refugees in 1921 by the League of Nations and the appointment of Fridtjof Nansen as its head. The High Commissioner was charged with assisting Nazism led to such a very large increase in the number of refugees from Germany that in 1933 the League created a High Commission for Refugees coming from the conflict and the political instability during World War II led to massive numbers of refugees. In 1943, the Allies created the United Nations Relief and Rehabilitation Administrations, in short UNRRA, to provide aid to areas liberated from the Axis powers, including part of Europe and China. By the end of the war, Europe had more than 40 million refugees. UNRRA was involved in returning over 7 million refugees. The establishment of the United Nations, in short UN, in 1945 was a landmark in evolution of modern refugees protection regime. Under UN, the International Refugee Organization, in short IRO, was founded on April 20, 1946 and took over the functions of UNRRA, which was shut down in 1947. The IRO was a temporary organization of the United Nations with a mandate to largely finish UNRR's work of repatriating or resettling European refugees. It was dissolved in 1952 after resettling about 1 million refugees. Ultimately, on 14 December 1950, the UN General Assembly created the Office of the United Nations High Commissioner for Refugees, that is UNHCR, on 14 December 1950. UNHCR is mandated to protect and find durable solutions for refugees. All refugees in the world are under the UNHCR mandate, except Palestine. However, Palestinians Arabs who fled the West Bank and Gaza after 1949, for example, during 1967 Six-Day War, are under the jurisdiction of UNHCR. UNHCR provides protection and assistance not only to refugees but also to other categories of displaced or needy people like and in second place, major refugees population of the world. Palestinians 4.8 million, Afghan 2.9 million, Iraqis 1.8 million. In 1951, UN Convention relating to status of refugees. A refugee is someone who has a well-founded fear of persecutions because of his or her race, religion, nationality, membership in a particular social group, or political opinions. In 1984, a colloquium of Latin American government representatives and distinguished juries adopted the Cartagena Declaration. Like the OAU Convention, the declaration adds a more objective-based consideration to the 1951 Convention of Refugees, and this definition includes persons who have to flee their country because their life, safety, or freedom have been threatened by generalized violence, foreign aggression, internal conflict, massive violation of human rights, or other circumstances which have seriously disturbed public order. In the first place, let's see international laws and standards regarding this regime. The 1951 Conventions relating to the status of refugees and its protocol. The Conventions relating to status of refugees is the foundation of international refugee law. The Refugee Convention defines the term refugee and sets minimum standard for the treatment of persons who are found to qualify for refugee status. Because the convention was drafted in the wake of Second World War, its definition of refugee focuses on persons who are outside their country of origins and are refugees as a result of events occurring in Europe or elsewhere before 1st January 1951. As new refugee crises emerged during late 1950s and early 1960s, it became necessary to widen both temporal and geographical scope of the Refugee Convention. Thus, a protocol to the convention was drafted and adopted. The 1967 Refugee Protocol is independent of, though integrally related to, the 1951 Convention. The protocol lifts the time and geographical limits found in the convention's refugee definition. Together, the Refugee Convention and the Protocol cover cooperating with UNHCR in the exercise of its function and facilitating its duty of supervising the application of the convention. As on 7 January 2015, 145 states are party to 1951 Refugee Convention. It is also worth mentioning that the principles of non-refoulement is explicitly or through interpretations prohibited by a number of human rights instruments, and moreover, it is widely accepted as a part of customary international law. Apart from this, UN General Assembly adopted the 1967 Declaration on Territorial Asylum, reiterating that granting asylum is a peaceful and humanitarian act that cannot be regarded as unfriendly act by any other states, and not that it is the responsibility of the country of asylum to evaluate a person's claim for asylum. The word asylum is nowhere defined in international law, but it has become an umbrella term for the sum total of protection provided by country to refugees on its territory. The United Nations Human Rights Council, a body comprises of 47 states, has established various mechanisms to investigate human rights thematic issues and the country situations. One of the features of these specialized procedures is that they allow actions regardless of whether a state is a party to the international human rights treaties or not. The special rapporteurs or special bodies such as UN Special Rapporteurs on Tortures, Summary Executions, UN Working Groups on Enforced Disappearances can intervene with the government concerned to prevent refugees, asylum seekers, or internally displaced persons from being subjected to imminent human rights abuses or violation of principle of non-refoulement. The conflict that accompanied the end of the colonial era in Africa led to a succession of large-scale refugee movement. This population displacement prompted the drafting and adoption of the 1969 OAU Convention and its 1967 Refugee Protocol. The OAU Convention is, to date, the only legal binding regional refugee treaty. Perhaps the most important portion of this convention is its definition of refugee. The declaration is not legally binding on states. Most Latin American states apply the definitions as a matter of practice. Some have incorporated the definition into their own national legislation. The declaration has been endorsed by the Organization of American States, OAS, the United Nations General Assembly, and UNHCR's Advisory of Refugee Law. UNHCR Executive Committee, in short, EXCOM, advises UNHCR on the exercise of his or her function. The annual conclusions adopted by EXCOM form a part of framework of international refugee protection regime. They are based on the principles of Refugee Convention and are drafted and adopted by consensus in response to particular protection issues. The adoption of national refugee legislation that is based on international standard is a key to strengthening asylum, making protection more effective, and providing a basis for seeking solutions to the plight of refugees. Incorporating an international law into national legislations is particularly important in areas in which Refugee Convention is silent, such as procedures for determining refugee status. International refugee law is part of a large mosaic of international human rights law and international humanitarian law. Human rights laws constitute the broad framework within which refugee law provisions should be seen. The International Covenant on Civil and Political Rights has been interpreted to prohibit to those countries where refugees may be tortured. In addition to it, nearly all the provisions of International Covenant on Civil and Political Rights apply to non-citizens as well. Refugees are entitled to two partially overlapping set of rights. They are those rights accorded to them as individuals and guaranteed under international human rights standard and national law, and specific rights related to their status as refugees. Two international human rights treaties have a particularly significant role in international refugee law, namely the International Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 1984. This convention provides for protection from refoulements or forced return to situations where there is a substantial risk of tortures, and another convention is the Convention on the Right of Child, 1989. This convention specifically stipulated that every child seeking refugee status has a right to protection and humanitarian assistance in the enjoyment of the rights set forth in their conventions and in others to which state is a party. In addition to this, because many refugees find themselves in the midst of international or non-international armed conflict, refugee law is often closely linked to humanitarian law. My dear students, now we come to the final part of these discussions. That is the concluding part of this lecture. Nobody wants to be a refugee. It is a matter of great misfortunes. It is the responsibility of state to protect their citizens. When governments are unwilling or unable to protect their citizens, the international community then step in to ensure that those basic rights are respected. If the evolutions of international refugee protection regime as outlined earlier highlight anything, it is that refugee protection is and must remain not a static but rather a dynamic and action-oriented function. Defining the future agenda for protection must be firmly grounded in consensus around the fact that refugee protection is first and foremost about the meeting the need of vulnerable and threatened individuals, not those of states. International solidarity is the need of the hour to safeguard and protect refugees in the present scenario. This is all about refugees and United Nations. Thank you once again, my dear student, for your patient hearing to my lecture. Thank you.